By the way, do you have some kind of like honorific on your name? Are you like Timothy Ayer Esquire?
Yeah, I mean, I sign stuff as, Timothy Ayer Esquire when I'm being a lawyer.
Okay, cool.
But you can go, Esquire, attorney at law. I mean, technically, you can demand people call you doctor, but nobody does.
I've always thought attorney at law was a funny name because, like, what else would you be an attorney at? Like, attorney at sports.
I think it goes back to there used to be a difference between law and equity, and a legal remedy would be a remedy where you get money. An equitable remedy would be a remedy where the court orders the person to do something.
I see.
I don't know though. That's just
attorney at equity does not sound nearly as cool.
No, it certainly doesn't.
So let's get the disclaimers out of the way first for people. What we're going to talk about is general information, and so your specific legal questions should be actually directed to a specific attorney.
Yeah, if you're going out to actually engage in a protest and you have specific questions, can I do this? Can I do that? You should speak to an attorney yourself who is your lawyer, who you can have a confidential conversation with, explain your situation, your intent, what you want to do, what's going on, and they can give you an actual opinion more relevant to what you're going to do. This is to be for general information, highlight issues, give you basic idea of what you're looking at if you're going to engage in this, but specific questions should go to your own lawyer.
Yeah, and so in order to be like as informative as we can be, we're speaking in a way that is specific to New Hampshire. But then there's also not a lot of guidance in New Hampshire.
Right. New Hampshire is a very small state, and we don't have as many cases as, say, Massachusetts and New York. Mm-hmm. So we have some statutory law, we have some case law, but it's not as much as in other states, and there's not a lot of guidance for every little specific situation out there. So a lot of the advice you have to give to people is basically a best guess based on the existing law. But like if you look at case law, like I said, bigger states, like Florida, New York, California, you may be able to find some specific guidance where somebody tried to do what you're doing, and you can have a better idea of how a court would address it. One of the nice things about New Hampshire is it's a small state, but one of the difficult things about it is that means there's not a lot of specific guidance. And so even if you talk to your own lawyer, you may not be able to get a specific answer other than, here's where the law is right now, here are the issues you may run into, here's how we can argue it, here may be the stumbling blocks, and beyond that, I can't promise you any sort of outcome.
So our other disclaimer we got to give is that this podcast is in no way intended to tell people how to break the law.
No, I am ethically forbidden from telling people how to break the law, and I don't intend to do that. This is more to give you people an idea of what issues may be out there, what pitfalls there may be, and a general idea of if you end up in a bad spot, how it could get worse and how it could get better.
So my first question for you then is, if a person was going out to protest, what sort of preparations could they make to take care of themselves, in general?
First and foremost, figure out what the protest is that you're going to. The big dichotomy is, are you going to a protest where people intend to get arrested, or a protest where people don't really want to get arrested? Because sometimes people go out with the intent of getting arrested. Maybe not necessarily that they intend to break the law, but they figure if I do X, Y, Z, I'll get arrested. And so get an idea of what it is that you're getting yourself into. Is it supposed to be peaceful? Do they have a permit? Or is it more along the lines of rabble-rousing, no permit, and we're going to cause some chaos? That way you know what you're getting into and what to expect. If you have any concerns about that, again, talk to a lawyer, especially a lawyer in the area, may be aware of the protest that's happening, may not be, but you can talk to them about your specific protest and see if they have any advice for you, suggestions, or any insight. The other benefit of talking to a lawyer in advance would be that you get their card, they become your lawyer, and so getting through to them if something does go wrong would potentially be a little bit easier for you, and you have a specific phone number that you can memorize. The lawyer has some background, they know you, and so they can work from a more informed position if they do have to do some work. So
memorizing phone numbers is so important, because I can barely tell you my wife's phone number.
Yeah, and we see that a lot in criminal defense now that we have dedicated cell phones with just have the person's name on them. You'd be surprised how many phone numbers that you don't know. And, I can remember back to high school where I used to have all my friends' numbers memorized, and I know I can tell you my wife's phone number, but beyond that, it becomes a little bit difficult. So you do need to put in a little bit of groundwork, memorize some numbers before you go out. Spouse, significant other, best friend, emergency contact, your lawyer, just have a few in your head, because may not happen, but if you do get arrested and your phone does get taken, what's in your head may become important.
Now, regarding phones getting taken, you had another piece of advice about that, about locking your phone with a PIN number and not biometrics. Why is that?
Well, that is because there's two types of evidence in a case. Well, there's a lot of types of evidence in a case, but when you're talking about verbal evidence, there's two types of evidence. There is testimonial evidence and non-testimonial evidence, meaning some evidence is simply background. It doesn't have to do with the specific facts of any alleged crime, and some of it does. So if you lock your phone with biometrics, the police can get essentially non-testimonial evidence from you to unlock your phone. Your fingerprint is non-testimonial. Your face is non-testimonial. Retina scan, non-testimonial. And that exists in a few areas of law, but specific to your phone, you can essentially be compelled to produce a fingerprint. Just like in any other case, if they want to fingerprint you, they can get it. If it's a PIN, they have to ask you to say something. They have to ask you to give some evidence. You have to say, the PIN to my phone is 12345, to quote Spaceballs. And in doing so, you make an admission. This is my phone. I do know something about it. I do know how to get into it. And that is evidence that can incriminate you, because they found this phone. It may have some evidence on it. And oh boy, we got your knowledge of that phone, and we can establish you have knowledge of that phone. And that is incriminating. So when the police ask you what's your PIN, you can plead the Fifth Amendment. You can say, I'm exercising my right to remain silent, and I'm not going to respond to that. And you're on a much stronger ground in that way.
So now let's talk about, if you do get arrested, if that occurs after hours, right? That's one reason to have an attorney's phone number on hand, but you'd want to have a conversation with them beforehand. This is within the scenario where you are intending to get arrested at a protest, I guess, right? Because you're in advance talking to a lawyer.
Well, maybe not intending on getting arrested, but maybe you're going into something thinking it might happen. Because I think a lot of people get caught up in these where they don't intend to get arrested, but things develop and you end up in a situation that you never intended to be in, and things are starting to go downhill quick. And so if it looks, again, but that goes back to preparing for the protest, figuring out what am I getting myself into in the first place. So even if you don't intend to get arrested, sometimes if you get the sense that this may go south, talk to a lawyer just in case. And the worst thing that happens is you never have to call the lawyer again.
And I guess one thing that we should back up and say too is that one way to find out or to get a sense of what the protest is going to be like is you can reach out to the organizers. That's at least a lot of the time, especially seemingly in New Hampshire, you can really find out who's organizing a protest and get in touch with them, on Instagram or whatever, and get a sense of what the plan is ahead of time.
If you can't get in touch with the organizer, that's a data point as well.
Right. True. Good point. Let's talk about bail money.
So generally, and again, we're talking about sort of different levels of situations here. Generally, if it was a largely peaceful protest and you do get arrested for disorderly conduct or loitering, or like a low level property destruction or something like that, and especially these days with COVID, they're trying not to arrest people. They don't want people in the jails, so they want to bail you out. But sometimes what happens is they have to call somebody called a bail commissioner to come in and set bail for you. And so you get arrested, they bring you back, they process you, they get your name, some information from you, call the bail commissioner. You got to pay a $40 fee to the bail commissioner, so keep $40 in your pocket just in case. And then you get released on what's called personal recognizance, meaning no cash bail. You leave with a court date, show up in court on this date and time. Now that's a little bit different under COVID. They're not doing arraignments right now. They're setting cases for status hearings, but absent COVID, you'd be arrested, processed, and given an arraignment date and released. But the bail commissioners do charge a fee, so keep $40 in your pocket.
Is that generally what you meant, by the way, by just general arrest procedures, or is there any other information about getting arrested that we should get in here?
I mean, you can go into any sort of detail that you want. You get into a lot of sort of arguments about exercising every right absolutely versus taking a practical approach to it and just trying to make it as low impact as possible. For example, when they're doing the processing, you can always not identify yourself, not give your date of birth, not give your address or anything like that. But what that results in is you're determined to be non-cooperative, and that can hurt you in the bail assessment.
I see.
They're going to ultimately figure out who you are. They're going to need some contact information from you, and that'll just help you get out without, again, being determined to be uncooperative.
Now, by doing that stuff, I know that like invoking the fifth can be kind of tricky, right? So
Yeah.
by doing that stuff, by giving them your name and your address and anything, if you'd previously said, I'm invoking my right to the Fifth Amendment, do you invalidate that by doing that or no?
No, you can invoke your Fifth Amendment right at any time.
Okay.
So if you're on scene and they arrest you and they put the cuffs on you and they say, what were you doing? You can say, I'm invoking the Fifth Amendment. I'm remaining silent. I want to talk to my lawyer. And then they get you back to the police station and say, what's your name? Give them your name, Joe Smith. Where do you live? 4 Elm Street. What were you doing out there tonight? I'm invoking my Fifth Amendment right. I'm not going to say anything else. And there's a difference between the general processing questions and then questions about the alleged offense. And so you can always invoke it. You can give what information is necessary to get yourself processed and out and continue to invoke your Fifth Amendment right.
Okay, that makes sense. In your email, you'd mentioned that you should keep your attorney's business card in your pocket and just give that to the officer. I can see that as being a way where you're somehow being both difficult and easy,
Yeah.
Like you're invoking your rights. Here's the lawyer I want. I'm being easy in the way that I'm going to be difficult to you.
Right. And it helps on a couple fronts. One, it means you only have to memorize your significant other's phone number and you have your lawyer's number in your pocket, which, is helpful if you don't like to memorize phone numbers. Mm. And 2, it lets the police know that you do have a lawyer, there is somebody. And then by doing that, you're essentially invoking the Sixth Amendment right to counsel, because at the time you're arrested and they're charging you, a proceeding is beginning and your Sixth Amendment right to counsel comes into play. And so you're identifying the lawyer, you're making sure you're giving them evidence that you have a lawyer. And so it just further protects your rights without them really being able to question it.
All right. So far, a little bit of advanced planning, a little bit of cash in the pocket, maybe a lawyer's business card. Let's talk about what you should tell other people, like your buddies, the other people who are going to be keeping track of you.
Well, that really, it requires a little bit of pessimism because, in an ideal world, you're going to go out, you're going to protest, and you're going to come home and everything's going to be fine.
Right.
So a lot of this is for, maybe not the worst case scenario, but a bad case scenario where, you do get arrested and charged with a low-level misdemeanor or something like that. You want to make sure that information can get out and that people can know about that, even if you're not in a position to tell them. And so there's a few ways you can do that. First, make sure somebody who's not going to the protest knows where you're going to be. And by where you're going to be, make sure they know, most importantly, what town you're going to be in. Because in New Hampshire, most police departments are local to the town. And so if you say, I'm going to go protest in Concord, and then you're not home by the next day, they know that maybe they should call the Concord police. If you say I'm going to go up to North Conway, they know to call the North Conway police and look for you that way. So make sure they know where you're going to go, specifically what town you're going to be in. Make sure that person knows the plan. Do you expect to be back by midnight? Do you expect to be back the next morning? At what point should there be a concern there? If you can, go with a buddy who's going to be there with you. So have somebody who's there with you who can keep an eye on you, who can report back if you get arrested, who can take a video if you're getting arrested. I guess a little more practical advice. If you get arrested and your car is stuck downtown, they can drive your car home so you don't get towed. So It's good to have a buddy with you, and it's good to have a kind of remote buddy back at home just so they can keep tabs on you. You know, again, not the worst case, but a bad case scenario that you hope never happens, but it helps to think that if it does, I've got this in place for it.
Right.
And then just generally make sure everybody's aware. You know, make sure your buddy knows that they're your buddy.
Yeah. Okay. That's good. Another good tip that I didn't realize was, I mean, this makes sense, but it's one of those things when you say it out loud, you're like, oh, this really makes sense, is don't be like drunk or on any other substances.
Yeah.
Like, go to a protest.
So back to that whole part where they'll process you out and give you a, bail setting of personal recognizance. If you're drunk, they might not let you out. They might do a hold on you for a while. If you've got another substance in your system and you're belligerent or they feel like you can't take care of yourself, you might not get out as quickly. And you make worse decisions if you're drunk. If you're at a protest and you're drunk, more likely that you may escalate things without really wanting to. So try to be sober.
So there are things that are like obviously illegal, right? And then there are things that are not so obviously illegal in like a protest situation. You can't punch anybody out anytime, so you can't in a protest. You can't legally steal anything in normal situation. You also can't in a protest. But can we talk about the First Amendment's impact on like disorderly conduct or like quote unquote rioting or stuff, that kind of thing?
Yeah, when you get into crimes that involve, making loud noises, being somewhere you're not supposed to be, engaging in some public display. You see this a lot with our disorderly conduct is the big one. Riot, which is essentially disorderly conduct in a large group of people. And then there's a couple theories of harassment that involve, being somewhere you're not supposed to be, saying things in a loud or offensive manner, saying things at an inappropriate time, where that really dovetails with the fact that, yes, I intend to be out in public saying something that you may not want to hear. And I'm out in public saying something in a way that you may not want to hear it. And I'm trying to do it in a way that makes you notice me. So if you're charged with a crime that has anything to do with that, then the First Amendment can be a complete defense to it. There's limits to it. Like, you're outside screaming and, you're doing it in a way that somebody, some other person is just severely upset by it. Or you're outside in a place and you're blocking traffic. You can't do those things, but to a reasonable degree, with some of those crimes, the First Amendment does present a defense to it, because by criminalizing your activity, it's essentially quelling a legitimate protest, which is a First Amendment right.
Okay, that makes sense. One thing that people have obviously been seeing a lot of on social media is videos of the police arresting people or, doing other things to them. What's the legality of recording the police?
New Hampshire has a pretty vigorous wiretap statute. So the big difference in a lot of states is there's what's called one-party states and two-party states. In a one-party state, one person can record a conversation without telling the other person, and that's perfectly legal. In two-party states, each party to the conversation has to know and consent to it being recorded. New Hampshire is a two-party state. You have to have consent of all parties to a conversation before you can record it. And that applies only to audio recordings. So silent video is fine. Taking pictures is fine. But when you get to audio recording, it is pretty heavily regulated, and there's some pretty complex statutes on it. So the basic premise is you cannot record a conversation without consent of all the parties to that conversation. The catch is that consent can be implied. And you can imply consent from people's actions, from what you know about the situation. And then your mental state with regard to that implication is also relevant. So, for example, you didn't ask me before we started this podcast, can I record this, and get me to say, yes, absolutely, you have my consent to record it. But if I contacted the police afterwards and said, oh my God, Zach recorded this podcast, and he didn't get my explicit consent. If they didn't just laugh me out of the police department at that point, you could point to all of the emails back and forth between us. Mm-hmm. You could point to the fact that Zoom says recording, and then I'm sitting here talking to you and say, listen, there's no way he didn't know, there's no way he didn't consent. Look at all of this evidence that he was perfectly fine with it. And that would be a defense to, any criminal charge arising from violating the wiretap statute. And to be clear, you can be charged with a misdemeanor and or a felony for violating the wiretap statute, which is why this is so important to consider. Mm-hmm. So taking all that into consideration, if you're in a protest in the street, the press is there, and you're taking a video of it, you've got a pretty good defense. I'm not going to say there's no way you get convicted, because I can't say that. But you've got a pretty good defense that, listen, people were there. It was a very public thing. They intended for people to pay attention. They weren't trying to keep it private. There were people recording everywhere. Everybody saw it happening. Everybody essentially consented to this being memorialized in this way. So depending on your circumstances, it's likely that you can take a recording of it. And where the police are engaging in activity, you have a constitutional right to record the police engaging in activity. And not in New Hampshire, but in other states, that federal constitutional right to record the police because they're public officials has been found to trump wiretap statute. So again, likely that you would be able to record it, but again, your specific circumstance is really going to govern that.
Okay. I'm not a person who messes with the cloud. You know what I mean? I don't trust it. I don't believe in it. All my stuff is backed up on hard copies. But you had said that it's a good idea to want to have your recordings that you might be taking at a protest backed up to the cloud so that someone else can access them.
Yes. And again, this is a bad to worst case scenario where
Right.
you get arrested. You may have been arrested illegally. They've seized your phone. You don't have access to it. And so you're sitting there in the police department with no phone thinking I've been arrested illegally and somebody needs to know about this. The best way to make sure that somebody can know about it is, A, you have their phone number memorized and maybe you can call them and tell them. But B, as you recorded and saved that video, it got backed up to your iCloud account or something like that. Somebody can log in and pull the video, get it to your lawyer if they feel like they can get it to the press, and they can start taking action with it, because it may be a while before you get your phone back if they have seized it. And so it just ensures that the evidence doesn't get destroyed, that it can get to somebody and it can get around quickly, and that somebody external to you in the moment can get to it. Now, I'll say along those lines, though, there's some precautions you want to take with that too, because there is a large amount of case law in a lot of different areas of law surrounding the police's ability to get into your cell phone, get a warrant for it, get a warrant for your iCloud account, things like that. And a cell phone is essentially a vehicle to get into the majority of your life and a lot of personal information that you may not want them knowing about. So, absolute best practice is you go there with a new phone, with a new iCloud account, with nothing else on it. And so if it gets seized, there's literally no way they can get into the rest of your life. It's not realistic for a lot of people, which is why you want to have the PIN instead of your biometric data. You may want to set up a dummy iCloud account or set up a different cloud account that just has information about the protest itself, because it's not realistic for most people to go out and buy a second phone for these purposes. If you can back up your entire phone and you feel comfortable backing it up and wiping your physical phone that you bring with you, that's also fine. So you do a full backup. You then do a hard reset on your phone, go back to the factory settings, and then set up a second iCloud account for that to go in, or a second cloud account for that to go. But at the very least, you want to have the pin on your phone. You want to have it backed up to some cloud account that somebody else can access, and so they can get the video and get it circulating if need be.
If you are confronted by police officers, what are some sort of just general things to know, including like why you shouldn't get in a fight with them?
A lot of reasons for that, because they're probably, basic premise, they're better trained than you and they're going to win. When you end up being addressed by officers in a way that, they're coming into physical contact with you and they're trying to either restrain you, or they're trying to stop you temporarily, or they're trying to arrest you, you're in a very interesting combination of practical and constitutional considerations, and statutory. There's a lot of statutes that govern it. In general, if an officer confronts you to arrest you, you cannot physically resist in any way. New Hampshire has a very broad resisting arrest statute. It is a crime to resist a legal arrest, and it is also a crime to resist an illegal arrest. So even if you think they can't be arresting you, you cannot physically resist. That will still be a crime. The police can use force to arrest you if they feel necessary. They can not use unnecessary or unreasonable force, and they can't use force if an arrest is illegal. But those are all determinations that get made after the fact. You are not allowed to make that determination for the officer in the moment. And if you do make that determination, the officer likely disagrees with you and will continue to arrest you. If an officer does approach you to arrest you or restrain you, the best thing to do, let them do it. Don't resist. And to be clear, the resisting arrest statute is for physical resisting. You can't physically resist. But you can also assert your constitutional rights. You don't have to talk to them. You don't have to consent to a search of your person. There are certain things they can search for, like they can search you for weapons and they can do pat downs, but you don't have to consent to any of it. They can then arrest you. They can bring you back to the station. You don't have to talk to them. If they ask you questions, you assert your Fifth Amendment right. And then if what they did was illegal, if it was unreasonable, if they shouldn't have done it, that gets litigated after the fact. And you can deal with that with the judge after the fact, but that does not happen in the moment. Mm-hmm. Any resisting, any fighting, any struggling only makes that case worse when the judge is reviewing it. So you want to have the best record you can moving forward. You did everything you could to comply and be peaceable. You weren't doing anything wrong. And Your Honor, this is what the officer did. And so if you think that you're being arrested illegally or they're using unnecessary or unreasonable force, the best thing you can do is not exacerbate it. And it's tough. It's tough in a lot of scenarios, but you've got to grin and bear it. And you've just got to go as peaceably as you can.
Okay, so let's talk about when you are in custody or not in custody, because there was some stuff that you wrote to me that I was surprised by. Like, first of all, that police don't need to read you your Miranda rights no matter what.
Correct. And that's something we get in a lot of cases where people think that the case has to be dismissed because they didn't read me my rights. That is not. So the Miranda rights that we always hear are you have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. You cannot afford to hire an attorney. One will be appointed for you. Those rights exist to effectuate I'll use the technical term, the Fifth Amendment right against compelled self-incrimination. And what that means is you cannot be made to incriminate yourself. There's two ways that right exists. One way is an officer just walks up to you on the street and says, "You murder anybody today?" You don't have to say yes, even if you did murder somebody. You say, "Officer, I'm choosing not to answer that question." And if you're not in any sort of police custody or restraint, it's your obligation to assert that right. The officer does not have to read you your rights. When the officer has to read you your rights is when you have been arrested or you're under what's called a functional equivalent of arrest, meaning a reasonable person in your circumstances would not feel free to leave. At that point, the U.S. Supreme Court and all the other courts in the country essentially have found that the situation is so overbearing that your will to resist saying anything is overborne. And it is essentially per se compulsion to speak. And therefore the officer, before questioning you, has to remind you that you don't have to talk to them before they can engage in questioning in order to reduce that feeling of compulsion. Now, to be clear, many defendants and many defense attorneys have a very different view of what is the functional equivalent of arrest than many police officers, prosecutors, and the law. For example, if you've been pulled over for a DWI and they're doing the field sobriety tests, you, as a layperson, me, even as a defense lawyer, would not feel free to just say, "You know what, officer, I'm out of here. I'm going to go." You wouldn't feel free to do that. You would feel compelled to stay there, and you would feel like I am in police custody. The case law disagrees. That is not a situation where they have to read you your Miranda rights before questioning you. They have found that the traffic stop is not the functional equivalent of arrest, and Miranda does not apply there. So when you're trying to gauge the situation, the case law has a stricter line than you may feel in the moment. But to be clear, the big dichotomy here is, are you in police custody or not? If you're in police custody, they have to read you your rights before questioning you. If they arrest you without questioning you, they don't have to read you your rights. If you're not in police custody, it's on you to say, "Officer, I'm not answering those questions. I don't want to talk." Even if they don't read you your rights, it's on you to do that. If you're being arrested, if you've got the cuffs on and they don't read you your rights, that doesn't mean that they have to dismiss the case. It just means that anything you said can't necessarily be used against you. Now, if you're arrested and you're in the back of the police car and they're not asking you any questions, and you say, you know what? I stole $500 in the bank while I was out there. That can come in against you because they didn't question you. You just blurted that out.
Mm-hmm.
But if they're going to question you to try to get information from you and you're under arrest, they have to read you your rights, or they can't use your statement against you in court. If they haven't arrested you, if you're out on the street and they just approach you and ask you what you're doing and you say something without invoking your right, they can probably use that against you. At that point, it's on you to say, I'm not talking. But to be clear, in any situation, your Fifth Amendment right to remain silent applies. Your Fifth Amendment right to say, officer, maybe I'd be happy to talk to you, but I want to talk to a lawyer first. That applies in every situation. But when you're not in police custody, you have to affirmatively invoke it without them reading you your rights.
Yeah, is there a wrong way to say it?
There is never a wrong way to say I'm invoking my Fifth Amendment rights. You just need to be very clear. I'm choosing to remain silent. I'm exercising my Fifth Amendment rights. Or I want to speak to a lawyer. I'm exercising my Fifth Amendment rights. And you have to make sure that it's unequivocal.
Okay, that makes sense. That's a good bottom line version of it, because it's definitely tough the way that some of this stuff, the way the places where the line is, it's not exactly where you'd think it would be.
No, but that's why it always gets hashed out after the fact. And the best thing you can do is do your best to invoke your rights and be peaceable. And so if it does have to get hashed out after the fact, you have as good a record as possible.
For people who are interested in getting deeper into this stuff, getting further in, what are some places you would recommend that they go, or people that they talk to?
Talk to your friendly neighborhood defense attorney. That's probably the best, if you have specific questions, the best thing to do, because they may not have all the answers, but they're likely able to help you find the answers. If you want to do a little bit of Googling, there's plenty. If you Google it, you'll get Wikipedia articles. You get articles everywhere. Specifically, there are resources through the American Civil Liberties Unions of the ACLU and the ACLU of New Hampshire. The National Association of Criminal Defense Lawyers is in the process of putting together a First Amendment strike force. And so they're putting resources together so if people do get arrested, especially en masse after a protest, defense attorneys can be available for them to help them. And then similarly, the New Hampshire Association of Criminal Defense Lawyers is working on the same thing. And so if you have any questions, again, the easiest thing to do is find a defense attorney near you and talk to them. You can also look on the ACLU's website, or the ACLU of New Hampshire, or the National and/or New Hampshire Associations of Criminal Defense Lawyers. And like I said, Wikipedia.
No, that's great. I think this is good. I think we've covered everything that we should cover. And I think most importantly for me, I did it in a way that is going to require very little editing. So I'm excited about that.
If we can reduce your workload, I'm all for it.
Yeah. Well, I'm starting a new job on Monday, so I gotta just gotta just crank this one out.
Are you technically unemployed this weekend?
Yeah. For 2 days, I'm unemployed. Yep.
Congratulations.
Yeah, it's gonna be fun. So, all right. Well, thank you so much for doing this.
Thanks for having me. This was fun.
I'm gonna stop recording.